I think we can start. Welcome everybody to this webinar about the state of play of the more economic approach in abuse of dominance cases. My name is Kai Kuhn. I'm a Deputy Director of the Center for Competition Policy at the University of East Anglia. Now let me say just a couple of words before we start about the CCP. It is a research and policy institute at the University of East Anglia that is very special in this type of area because it is truly multidisciplinary, involving economists, business economists, lawyers, and also political scientists doing interdisciplinary work. And the forum today, the CCP discussions, have been created in particular to have that conversation between academics from different disciplines talking about competition issues. And this is exactly the type of thing that we want to do, talk about these issues between lawyers and economists as on today's panel. That is kind of our mission in many ways, both in research and in the policy field. And let me just kind of tell you that next week is actually a big one for our program at the University of East Anglia, because there are going to be 3 days of summer school in competition policy, in which, for example, we have a number of lectures on competition economics, then followed again with me and Elias Deutscher in tandem in one case on discussions of cases between economists and lawyers. And at the end of the week, there is the annual conference of the CCP, in which leading research in different topics in competition policy is going to be presented at the University of East Anglia. For today, let me introduce the speakers. First of all, it's Elias Deutscher, who teaches at the UEA in the law school and is the lawyer on our panel, while I'm going to be the economist in the minority for today, because the person who is leading this discussion as the moderator is Anna Markuli, judge at the European Court, and just as importantly, of course, a graduate and alumni of the University of East Anglia, where she did her LLB, and therefore we're particularly happy that we could convince her to chair this session today. We always try to have someone from outside for chairing the session. It's especially nice to have a judge here, and the chair position allows people to say something and be actively involved in the conversation, but also not say anything when they don't need to or don't want to. And so I think we have the ideal setup to talk about a topic that's, I think, broadly discussed, and where I think the conversation between economists and lawyers is particularly important. So with that, I hand over to you, Anna. Thanks very much for joining us and doing this today. And I'm looking forward to our discussion.
Thank you very much, Kai. Thank you to both you and Elias for inviting me to this discussion. It's always a pleasure to be back and be involved in any initiatives of the University of East Anglia, and in this case of the Center for Competition Policy. So as you said, I will profit from my function as a chair and moderator in this discussion to jump in and out of the discussion as I see as I consider necessary. Just to stress from the beginning that whatever comments I make are my own personal capacity and my own understanding of the case law. So we could start without further ado, and I think it would be good to start this discussion first to set the scene and see how the evolution in the abuse of dominance in cases before the court has evolved over the years, and especially since 2008, when the guidelines of the Commission were adopted, and reaching the Intel appeal judgment, and even further than that. So on that point, I will ask Elias to kick off with some elements, and then we will follow with Kayo accordingly. So Elias.
Yeah, first of all, thank you, Anna, for your kind introduction, and also for being prepared to chair this session. It's really a great pleasure for us to have you with us. And so to kick off the discussion, I think it might be useful quickly run through the evolution of the abuse of dominance case law, in particular since Intel, which has been really a watershed case in this respect. And what we have seen since Intel is that the court, and also the general court, in the interpretation of the abuse of dominance case law, has shifted from a more skeptical approach towards the more economic approach, which was outlined in the guidance by the Commission, towards rather a full endorsement of this more economic approach. So prior to Intel, you had judgments such as Tomra, Post-Denmark 2, but also the General Court's initial Intel ruling, which was somewhat critical about the Commission's guidance, at least some elements in the guidance. And what we see since Intel is really a move towards a full endorsement. And this endorsement is reflected, I think, in 3 core principles. So the first core principle is that the Court of Justice has recognized what lawyers nowadays call the as efficient competitor principle. So the court already in Post-Denmark 1 and then in Intel has made it clear that Article 102 does not protect less efficient competitors. So the purpose of Article 102 is not to prevent dominant firms from engaging in conduct that leads to the marginalization or closure of competitors that are less efficient than the dominant firm, less efficient based on price, choice, quality, or innovation. The second core principle is what one could call the Intel burden shifting mechanism in abuse of dominance cases. So prior to Intel, in particular in cases involving exclusivity rebates, the European Commission relied on a broad presumption that exclusivity or loyalty rebates are unlawful. And this presumption was coined in the famous Hoffmann-La Roche case. And the basic clarification that Intel brought about is that dominant firms during the administrative procedure can put forward evidence that rebuts this presumption and that shows that the, for instance, rebates at issue are not capable of foreclosing an as efficient competitor. And if a dominant defendant puts forward this countervailing evidence, then the European Commission, first of all, is required to consider this evidence and also to sustain the finding of anti-competitive foreclosure effects by considering 5 factors. And I think, Anna, you call these factors the Intel factors. So the Commission has to assess the extent of the dominant firm's dominant position on the relevant market, the coverage of the alleged abusive conduct, so the market share that is covered by the alleged conduct, the conditions and arrangements for granting, for instance, the rebates in question, the duration and amount of the rebates, but also the possible existence of a strategy to exclude competitors that are as efficient as the dominant firm. And more recently, in the Intel Renvoi ruling, the General Court has made it clear that those 5 factors are cumulative factors. So if the Commission is confronted with countervailing evidence, the Commission then has to go through each of those 5 factors and must show that they are fulfilled. And what is, I think, even more interesting is that in Unilever, the Court of Justice has also clarified very recently that this Intel burden shifting mechanism and the Intel criteria are not confined to rebate cases or pricing abuses, but also might apply to non-price abuses such as exclusivity clauses. And then the last major principle that highlights this shift towards a more economic approach also in the case law is the endorsement, I would say, of the consumer welfare standard in the recent Servizio Elettrico Nazionale case. So in this case, the Court of Justice for the first time clarified that, I quote here, the well-being of both intermediary and final consumers must be regarded as the ultimate objective of the prohibition of abuse of dominance. And I think that has also been a major signal of a shift towards a more economic approach. And I think Anna will further elaborate how this evolution also then led to a more closer scrutiny of the Commission's analysis, both legal and economic analysis, in recent appeal cases such as Intel Renvoi, Google, Android, or the Qualcomm case. And I hand over now to Anna again.
But I think we can also take Kaiow's observations on this point, and then I can add a few things, as Elias has already made a very clear exposition.
Yeah, and I think we're going to come back also to Elias's points kind of in the next part, because I think we're going to talk a little bit more about the strengths and weaknesses kind of the test. But I think kind of one of the things that's also important to put these developments in a context of what we're seeing in other areas where kind of there seems to be an active development of trying to push back kind of the use of more economics in competition cases, both at the agencies and through regulatory intervention. So my impression is that the response to some of these developments has actually been more in the direction of saying, let's do less economics at the agency itself, because that just becomes risky. We've seen something similar in response to for example, UPS TNT. That one just does not want to put forward own analysis, because that then gives possibilities of challenging the outcomes. That doesn't mean that the economic analysis has become less in real cases, because I think from the point of view of firms, the importance of having kind of a strong case seems to have even increased in order to kind of have a chance to prevail potentially later in court. And so the interaction there between parties and agencies has actually changed quite a bit in terms of economics being used as a tool to attack, and then kind of it being more of importance to tear that down than anything else. And I think that has not helped kind of the economic analysis itself at the agency sometimes. But I think it's just a development to keep in mind. We're certainly kind of seem to be seeing something that in the courts, a development that we had 10 years ago or more at the agencies, while now the two seem to be going in somewhat different directions in the development.
Okay. So yeah, there are already a few elements, but I will just add my own understanding of the Intel appeal case. Maybe it's a bit different as a judge, but in my view, what the idea behind the Intel appeal case was that if an undertaking brings forward arguments and evidence showing that behavior was not capable of having foreclosing effects or restricting competition, the Commission has to carry out an analysis of the capacity of the behavior to foreclose as efficient competitors. And since nowadays most likely but a lot of the analysis is based on economic concepts and data, the Commission has to look at this evidence and closely as regards the whole context of the case. And I think this more economic approach that we have all qualified as coming through the Intel appeal case was something that was slowly being developed in the practice, both at national level and the European Union for some years now. It's just that economics have become more, let's say, obvious and have become more prominent in the examination of this case, and the court through the Intel appeal case has taken note of that and has clarified its case law, as Elias has mentioned, which was based, at least for rebates, on the Hoffman-LaRoche case law. And of course, such repercussions have an impact on the litigation stage, since if a company will contest the analysis of the Commission in the General Court, and that's where I think the court has made it clear, is that the court has to examine all the arguments that seek to bring into question the validity of the analysis of the Commission, and that includes complex assessments as regards economics as well. And then, as Elias said, we've seen that Intel Renvoi case, where I have to just make a point there that these 5 elements have been, it is the Intel Renvoi case who has qualified these 5 elements. We haven't really found that in another case so clearly in any case. And the fact that they have said in the General Court said in that case that all of those elements have to be analyzed by the Commission. In any case, in that case, the court examined the AEC test and has concluded that there were various errors that vitiated the analysis of the Commission, and therefore could not support its conclusion that the contact was capable of restricting competition. There we go. Then we go to the Google Android case, where for one of the contacts at stake, the revenue share agreements, there we had the court analyzing 2 of the elements, or the market coverage, and then, well, I wouldn't say 2, but let's say one clear one, so the market coverage, and then also the sufficient competitor test as performed by the Commission in this case. And there, the court found that the Commission's demonstration did not permit to consider that the market coverage was significant, as is requested by case law. It did not say how much is significant, but that the Commission did not prove, did not put in its case, did not prove through its reasoning that it was significant, and then went on to find that there were some errors also that vitiated the AEC test in the underlying the revenue share agreements. So the court, I think in this case, what my takeout is that the court did go into examining the AEC test in detail. So that was something that I think has changed compared to previous cases. So if I wanted to make a point, I don't want to take too much time, but Qualcomm, let's say, was a bit different, because there the court, having found that the theory of harm developed by the Commission, that is that the payments made by Qualcomm reduced Apple to turn to Qualcomm's competitor, were not supported by the relevant evidence in the case. So the court there did not analyze the Intel criteria, because it had already considered that the theory of harm was already invalidated. So There we have a bit of a different scenario. Of course, each case is different, but I think what we see, the concrete application of the criteria of Intel, as I call them, have been put into use in different ways. And there, I think it will be important to watch of course, we had the court confirming the line of Intel in the Servizio Elettrico and the SAN case and the Unilever case. But I think it will be important to see the appeals filed by the Commission in the Intel Renvoi case, and then the appeal filed by Google in the Google Android case, to see the limits of this more economic approach in the judgments. Of course, I think that would be really because preliminary references are more explicative of the state of the law. But then I think the more we go into these appeals, we'll see what the court will find on the limits of the more economic approach. So that would be a little bit my approach on the issue. And I don't know if you have any other observations on that, or we can move to more specifically the as efficient competitor test.
Okay, why don't we go there to the as efficient competitor test? And I think Elias has already mentioned a couple of things as kind of quite important changes that are actually at the heart of what the as efficient competitor test is trying to achieve. And I think it's important, first of all, to always make a distinction between what the as efficient competitor test or what people now call the as efficient competitor principle is, and what, for example, a price cost test is. I think that would be important to do from the start. In principle, the as efficient competitor test is a conceptual framework under which you are concerned about not preventing behavior that excludes inefficient competitors from the market. That's a really core idea of the as efficient competitor test, and it embodies that idea that competition policy does not protect competitors but competition. And I think what's important to understand that the importance of that also from the economic point of view is that we have a lot of evidence that a lot of the productivity benefits that we're getting is of competition over time, eliminating inefficient firms and therefore allowing and getting the space of more efficient firms coming into the market. So that turnover process of firms is particularly important for efficiency, and therefore protecting inefficient firms is a bad thing for the economy in the long run. So I think that's kind of the underlying idea of this. That doesn't say that this is covering everything that we should be concerned with in competition, and I think we're going to get to that later. Economists have criticized this heavily, and I think we're going to get to a discussion kind of what the role is in the AEC, and I very much like kind of this burden shifting approach that the court has taken with it, because I think one can fill it a lot with the economics of it. The second reason why tests like the AEC are so important, and also kind of a focus, for example, on the consumer welfare standard, is that those are tools in which one can define what actually relevant evidence is. And I don't think the court is quite there in terms of some of the things that are looked at in this checklist, because they're fairly ambiguous. But we are in a process in which we can kind of ask the question, what should we actually look at when we're asking the question, is the as efficient competitor principle fulfilled or not? One of those things is a price cost test, and it's important to keep in mind we're talking a lot about conditional pricing as the area in which this is being discussed. We have one area in which we've been applying this for a very long time, but are almost taking this as a standalone abuse, which are margin squeeze cases, where the margin squeeze as such is nothing else but an as efficient competitor test. And then the question is, can one rebut that there are actually efficiency reasons for that? And kind of one of the things that's actually important in that context, and why rebuttability also, even in that context, is important, is that we also know that even where we have, for example, in conditional pricing, for exclusion of firms, we very often get efficiency benefits that we see in studies. Sometimes we get reductions of competition in the short run, but we often get improvements in competition in the long run because there are incentives to invest, for example, in alternative supplies that then increase competition in the long run in the market. And so kind of in all of this area, the efficiencies of kind of exclusion, or the inefficiencies of exclusion or consumer harm, aren't very clear, and getting towards a clearer discussion of that is actually quite important. And just to give you an example, in a margin squeeze case, I always felt a little bit uncomfortable about the Slovak Telecom case, in which you have a competitor for clothes that then turns around and builds a fiber network in Bratislava, right? So there may still be an issue because you cannot do that in the rest of the country because the density is not high enough, but you still see that you have to be really careful about how you're applying this and how broad you're making the claims about the infringement. So I think what is important here to think about the AEC test is that in the end, kind of a price cost test is also only one piece of evidence. It works in some cases, but it doesn't work in other cases. And it's important to make that clear, because otherwise you start making distinctions between something like an exclusive dealing case and a cumulative discounting case, which in principle have the same effect, namely exclusivity. And as a result of that, so with exclusivity, of course, it's a quantity restriction in a sense. So you can't use a price cost test in order to test for the as efficient competitor test. You may be able to do that in other ways. In some of these conditional pricing cases, a price cost test works very well in order to kind of show that the as efficient competitor test is violated or not violated. What's really important, though, is to understand that the same principle is underlying everything, because you also want to have comparability. So one of the weird things by not having done that in the past is that some of the rules for exclusive dealing are actually much more lenient than for cumulative discounts, although the cumulative discounts may actually be applied over shorter periods of time than the exclusive deals are, which wouldn't make any sense, since the exclusive deal is a much stricter exclusivity than you're getting through the cumulative discounting. Now, the fact that we're now using something that's a coherent test actually allows us to have that discussion, to actually talk across different cases and ask about the consistency of different behaviors and their impact, and what the relative degree of intervention should actually be. And I think that's really the importance of having something like the AEC, with all the difficulties that we're going to discuss later on, as kind of one of the standards to organize the way that we think about evidence.
Okay, thank you very much. So Elias, if you want to.
Yeah, I think
in the legal aspect.
Yeah, I think I will just pick up on some of the points that Kayuwe made and reflect a bit upon the evidentiary role of the as efficient competitor test, and also this idea of the burden shifting. And I think the first point that I'd like to make is that the as efficient competitor test in the broad sense, so this as efficient competitor principle, is now, as I've mentioned already in the beginning, recognized as an overarching principle that governs all type of abuse of dominance cases. And so that's, I think, very much in line with Kai-Uwe's point that the as efficient competitor principle basically is the underpinning meta or the overarching meta norm of abuse of dominance. And so this is also clear that this as efficient competitor principle applies it both in pricing abuses, but also non-price abuses. And so from an evidentiary point of view, the European Commission is now required to show that this principle is fulfilled. And I think then the inter criteria are one way of doing so, and the price cost test is another iteration of the as efficient competitor principle. And then when it comes to this evidentiary role of the price cost test as the as efficient competitor test in the narrow sense, I think here the story is slightly different. So here we see that for some categories of abuse, such as predatory pricing, but also margin squeeze, as Kai-Uwe has mentioned, the price cost test is basically evidentiary requirement. Whereas for conditional pricing, so exclusivity rebates in particular, the court has made it clear, and the General Court has also followed this, that the as efficient competitor test, so the price cost test, is only one, albeit useful, tool amongst other tools to establish that the dominant firm conduct has the capability of foreclosing competitors. So here, there is no legal obligation for the Commission or national competition authorities to use a price cost test. But I think the third point here that is important, and I think that's also the major clarification that Anna alluded to in the first part, is that if the European Commission or a national competition authority uses the as efficient competitor test as in form of a price cost test as major evidence for finding anti-competitive effects, then this test has to be accurate, and the General Court then needs, as part of its judicial review, also to review the validity of the Commission's assumption and findings. And I think that is what played out then very prominently in Renvoi, in Google Android, and perhaps somewhat also in Google in Qualcomm. And I think the last point that I'd like to make about the burden shifting role of the as efficient competitor test is also that in Qualcomm, I think that's very prominent, but also in Unilever, the dominant firm can actually put forward its own as efficient competitor study in order to rebut an initial finding of foreclosure effects. So even if the Commission in the beginning didn't carry out an as efficient competitor test, then the dominant firm can put forward this test as countervailing evidence, and then the European Commission or the National Competition Authority has to consider this test and has to explain why the test doesn't show that the conduct is not foreclosing an as efficient competitor. And I think that was one of the issues in Qualcomm, although there are additional factors. So the Commission changed the theory of harm, and then there was a mismatch between the discussion of the as efficient competitor test by the Commission and the way how it was submitted by the parties. And I think the last point that I'd like to highlight here as well is that even in non-price abuse cases, the court has now clarified that a price cost test might be relevant. In Unilever, the court had this, and it is at least the obligation of the competition authority then to explain why it considers the as efficient competitor test as a price cost test as not a relevant piece of evidence in the case. And it must also highlight and show which other studies might be more relevant, or which other approaches might be more relevant in finding an abuse. And I think that is also an interesting development here, which goes again in the direction of Kai-Uwe's point about the consistency. I just wanted to also pick up on the very last point that Kai-Uwe made about the Slovak Telecom case, where I think, Kai-Uwe, you suggested it should raise some flags if the as efficient competitor test shows that a dominant firm's pricing conduct would foreclose an as efficient competitor, and the actual as efficient competitor then still is able to roll out a broadband network in Bratislava. I think that is really indicative of the fact that the court considers the as efficient competitor test as a test which looks at a hypothetical competitor as being the as efficient competitor. So the hypothetical competitor is not the actual competitor that is harmed by the conduct, but a competitor that has the same cost structure as the dominant firm. And I think that might explain why in Slovak Telecom, the court and the commission found anti-competitive foreclosure effects of an as efficient competitor, although the actual competitor was still able to roll out the network. And I think that shows somewhat a mismatch, perhaps also in how economists and lawyers conceptualize this notion of the as efficient competitor. And I don't know if you want to respond to that, or if Anna wants.
I should respond to that, because I think the point is the as efficient competitor test really asks if the behavior would be applied to the incumbent, right? Would it still survive? Which means if that is the case, then the competitor who's seeking entry is not as efficient, at least kind of in that context. Now, what we're not doing in those circumstances, and that's an important question. We're not asking the question how important the access actually is, right? So this is the direction in which the AAC test is actually over-inclusive, because we're not asking, because this is a typical thing when you're requiring access, that it reduces the incentive to actually create the input yourself that you need in order to operate. And this is kind of something that the economic literature has also shown, that if you are actually foreclosed, this is not unusual that you then make investments that allow you to compete in the market, that make the market in the long run more competitive. So that's the problem of being fairly restrictive, which doesn't say that the as efficient competitor test may not be restrictive enough in certain number of cases, right? But I think that is something, if one has the direct evidence that you are not foreclosed from the market, although you're foreclosed from the access to the product, then you don't actually have an anti-competitive effect, right? And I think that's an important element not to forget about this, because it's not always the case that the most efficient thing or the most competition enhancing thing is that you're actually getting the input from the firm that is trying to foreclose you, right? So then it is not anti-competitive foreclosure, it's just foreclosure, because you can get around it. And I think that distinction between anti-competitive foreclosure and foreclosure is not necessarily made through the AAC test.
Well, there are different variables to be taken into account. I agree that the AAC test is more wide than the price cost test. So there we have seen also in Google Android how it has been applied to as regards the conduct concerning the revenue share agreements. But taking a step back and looking at the general takeout of Google Android and Renvoi as regards the AAC test, I would think that what we can deduce is that it's not mandatory for the Commission to use the test. It can be useful in certain circumstances. And then when the Commission uses it, then it can expect that the General Court will review it, and in the light of the arguments, of course, of the applicant, whether it was conducted rigorously. On the other hand, I think the AEC test is not a factor that has a different or even higher weight than any of the other factors that or elements or criteria that were put forward in the Intel case. So it's just one among other elements. And as regards to which cases it should be applied or not, I think it was clear I think the court made it clear that it is useful certainly for pricing contacts. And then I guess that if we're going to discuss it later for as regards to what's the commission's conclusion that has been put in the modification of its guidance. But I do agree that the court has given a bit of more space to use the AEC test, and also commenting on the elements regarding the shifting of the burden of proof. I think that was something that the General Court took into account, and not only in the framework of its judgment during the litigation process, but more also prominently in the Qualcomm case, in the contradictory, regarding the contradictory nature of the administrative procedure as regards the AEC test. And there it sanctioned, the General Court sanctioned the Commission in a Qualcomm case, considering that the economic analysis brought forward by Qualcomm as a defensive element, which was a reply to the statement of the objections. Following that, the Commission modified the scope of the abuse, passing from one market from two concerned markets to one, without giving the possibility to the undertaking to adapt this economic test. That was for the court a restriction of the rights of defense of Qualcomm, because the court considered that the Commission was required to take into account the economic analysis put forward by the undertaking. And since the Commission modified its objections in a way that affected the relevant economic analysis, it had to give the opportunity to the undertaking, to the firm, to adapt its economic analysis on the basis of the new scope of the objection. So, and it has been also discussed that the General Court could have been was strict in this respect, since in this specific case, the modification was that it went from two relevant markets to one. Therefore, the impact on the applicant's defense couldn't have been negative. But of course, it is not possible to simply assume the result of an economic test based on costs of production and quantities of different and highly sophisticated products as chipsets are. And therefore, there were doubts created, since Qualcomm did not get the chance to respond. And also there was a finding in Google Android as regards the administrative procedure, where the court found that the contradictory nature of the proceedings were not respected as regards the AEC test. And there I would like also to bring in a question as regards the an element which, of course, having listening to Caio is always very interesting to hear the economists on these issues and the exchanges between economists of the parties involved. Of course, errors can be certainly avoided if you have a more robust discussion during the contradictory procedure, that was also what Kiowa mentioned, I think earlier, that some of the discussion is moved from the administrative phase to later. So that's how we pick up some of the mistakes later. But then on the other hand, one might wonder that both the Commission and the national agencies also have to strike a balance between respecting the rights of defense of the parties, but also ensuring that the length of the proceedings and the efficiency of these proceedings, especially if we're referring to digital firms, remains within a context that is manageable and does not protract unnecessarily. So that would be also some of the reflections that I would have on this. Also, this shifting of the burden of proof and how far one can go in the exchanges between the parties can go. I don't know if you have any observations on this. So you can.
I think this ties also in with our next sessions or next section on the challenges and the virtues of the as efficient competitive test. And I think, Jana, you explained very nicely this contradiction, the importance that the General Court now puts on the contradictory nature of the proceedings and the ping pong game that actually starts and is structured by basically the broad notion of the as efficient competitor test, and that also then plays out in the evidence that the parties can put forward by either presenting evidence that contests the Commission's price cost test, for instance, or by putting forward their own price cost test. And I think your last comment raises then the question about the administrability of the proceedings. So whether this sometimes doesn't go a step too far in actually requiring the national competition authorities and the Commission to meet a very high evidentiary burden. And I think what one can say just in very descriptive terms is that we have seen an increase in the evidentiary burden for the Commission or the national competition authorities, at least when it comes in particular to rebates cases. So prior to Inter, the Commission just had to show that the rebates were basically falling within the category of conditional rebates or loyalty rebates. Now the Commission has to respond at least to if the parties put forward evidence, at least to the 5 Intel factors, plus it has to respond basically also to the or carry out an as efficient competitor test. And here I think in the cases that you mentioned, what was very often contested was the contestable share of the rebates, which is one ingredient. The level of conditional rebates, which is a second important ingredient of the as efficient competitor test as a price cost test. Then the structure of the costs of the dominant firm. So what is the right cost measure? I think that was at stake in Google Android, for instance, and also sometimes the conditionality threshold. So we have the 5 Intel factors plus the 4 variables that you use for the effective price method as when you carry out the price cost test for rebates. So suddenly we have at least 9 types of evidence that the Commission or a national competition authority has to consider. And I think that's raising some questions about the administrability and just from observing how the evidentiary burden shifted. And then
during the administrative phase, of course, and having considered that the undertaking has brought all these evidence before the Commission.
Yes.
But maybe I can comment on that. Because I think there's an important point, and also kind of in terms of the role of the AC test relative to other evidence and so on and so forth. Because there's indeed, and if there is, I think indeed a really important trade-off in terms of what lawyers call legal certainty, and I would call really the fact that what competition policy is supposed to achieve is ex-ante compliance through incentives, so that the cases don't come up relative to something that is an ex post fixing. We're focusing more and more on ex post fixing and not on the original role of that. And of course, compliance is really easy if you have a per se rule, but a per se rule in the case of conditional rebate schemes is just simply makes no sense given the vast number of cases that we know in which these are efficiency enhancing and empirically have been shown to be efficiency enhancing. Not necessarily by a dominant firm, but that doesn't mean that with a dominant firm, it's necessarily so. And so the question is, how do you deal with the trade-off of administrability and actually giving the right incentives ex ante? And the AEC test is particularly good at this because the AEC test means that everything that you need in order to think about whether you're complying or not is information you have as the dominant firm.
Of course, of course.
So the AEC test as kind of the filter of saying, if you are passing it, you're much more likely to be on the safe side, is actually a really good one in order to reestablish the legal certainty that we're somewhat losing through losing the per se rules. And that should actually make it easier. My problem is adding this and basically saying it's just one thing with a similar weight with everything else, which are much vaguer kind of categories where I don't know how the commission is going to evaluate it, or afterwards the court is going to evaluate it.
I would totally agree, because I think that was the purpose of the AEC test, that the dominant company can do it at the beginning of its, before it decides how it will proceed. So
so I think and I think that's really important. Also, to the extent that the AEC, we know, also economically, and a lot of economists criticize it, is under-inclusive in terms of the things that it catches, right? There are situations where, you have a large part of the market locked up independently of the behavior, right? Asymmetric demand situation, entrenchment, and so on and so forth, where you might actually think that the right response, that actually the firm might be able to enter even as a less efficient firm if there wouldn't be behavior that's not profit maximizing by the incumbent. And there are also those tests that have been developed by economists, which are kind of like no economic sense test, or basically giving up profits in order to get someone else. Now, I think the point there, though, is, and there's a chance that we have also kind of with a burden shifting kind of pattern that has now been set up by the court, to basically say, well, if the AEC test is passed, there's still the possibility of coming back and saying, look, but here it is foreclosure and it is significant foreclosure. But then I think the standard of proof of that has to be relatively high also for the commission in order to maintain that economic certainty on these things. And I think that's possible because in a lot of the cases where it's really problematic, you do have some evidence also on intent, right, which is important. Or you can go on evidence, and I think there again, the Slovak Telecom example is an important one. If you kind of see that no one has ever managed to enter this market, right? And now the incumbent is not profit maximizing, and you can show that too, to some extent, is not profit maximizing, and because of that, the firm is exiting. Then you still have a good case. It may sometimes be also qualitative arguments, but they then have to be geared towards what we think is the real sign of what the firm is doing. So I think economically is giving up profits and keeping someone else out, for example. And if one staggers it like that and focuses the evidence, I think we can get a much better trade-off. I think what's problematic and what is, and I think Elias was pointing towards that, and basically saying, oh, there's a wide list of criteria that we can consider to decide. And then we're going to see whether it's been reasonably applied and sufficient. And I think that is actually problematic. The way of how we're tying our hands to evidence that's actually relevant to the theory of harm, and basically it has to be closely tied to it, and the degree to which we're actually saying we can at least not necessarily quantify it, but determine the order of magnitude of effects. That's kind of the standard we want to get to in order to actually have something that's solid and where firms can rely on it. At the same time, we can be relatively sure that we're actually getting the important cases, right? So that's I think we're undermining the gain that we're getting, but basically then going, well, but this is only one criterion under many, many criteria, right?
Yeah.
And we're seeing this already with the commission. We're going to get to that the commission says, oh, we don't need to use it. It's only one among many, many things. And we're going to decide which things we're going to bring forward. And that's going to be enough because this other thing is just a risk factor, right? And I think that is a real danger of the incentives that are being given to competition authorities in terms of how to try to.
Yeah. I think we have already moved to the next part.
Yeah, that was
quite smoothly, but maybe just to add to that, I think it's, of course, the Commission prefers. I would guess from what comes out of its new guidance, would prefer, given the results it has had from the court when it has applied the test, that it gives it a little bit, puts it a little bit on the bottom of its list. But in any case, if the undertaking uses it, then and has arguments on how the Commission has not taken it into account properly, then the court will review it, and it will sanction the Commission for not having taken it into account. Now, that's also it's the all relevant factors that have to be taken into account according to the court. So if what you're saying, Kaio, is that if the company wants to make good use of it, and then I think that's a very good point, because it gives certainty. Then if it presents it to the Commission, then the Commission has to take it into account. So it could come from both ways, and the court has already said that it will examine it. So I don't think it becomes such that there is an impediment in bringing this element, which could be useful eventually in the discussion. So I would, we're already in the challenges, the virtues of the test, and we have seen. I think Kaio really explained what are the elements that we have. That the virtues indeed of this test, and what are the challenges. I don't know if Laias, you have something else to add to this, because we're already at 4 o'clock.
Yeah. I think we wanted to just have a brief outlook, and I think this ties on also with the challenges and the virtues about the recent amendments that the Commission put forward with respect to the existing guidance, so the 2008 guidance paper, and also the announced reform of the guidance paper and the adoption of guidelines. And so I think this announcement should be read in light of these recent defeats also that the Commission had to or suffered in front of the General Court. I think the timing would suggest that this is at least some form of a response to that. And what is interesting about the amendment communication is that on the one hand, it just codifies some of the case law of the term. So this is with respect to margin squeeze There, the Commission, for instance, just says what the court have already established in Deutsche Telekom, Telia Sonera, that margin squeeze is not a subcategory of refusal to deal, but it is a distinct, independent form of abuse. Similarly, with respect to constructive refusals to deal, for instance, the Commission also follows here recent case law, which suggests that this doesn't need to be assessed under the Bronner test. So the Bronner criteria and the Bronner test are basically limited to outright refusal to deal. But on the other hand, what you also see is really this the pushback a bit with respect to the as efficient competitor test. And I think I'm rather, and also I wrote on this previously, I'm rather positive about some of those changes, and I then expect Kai-Uwe to disagree. But I think the first important point is that the Commission makes it clear that it will not necessarily only intervene if the conduct of the dominant firm leads to the full foreclosure of competitors, or the full marginalization of competitors, but also if the conduct only leads to partial foreclosure. So what does partial foreclosure mean? I think one criticism made by economists such as Steve Sellob was that the price cost test always assumes that conduct is only leading to foreclosure effects if it is shown that the as efficient competitor would leave the market, because at least in the medium term, because it couldn't survive the conduct of the dominant firm. And I think Sellob, for instance, makes it clear that also conduct that just raises the costs of rivals might have adverse effects on competition. The question then is how much this adverse effect on the cost of rivals needs to be for there to be a really anti-competitive foreclosure effects. I think that is one of the open questions that we will see. And then with respect to the as efficient competitor test in a broad sense, so the as efficient competitor principle, the Commission also makes it clear that under certain circumstances, it will intervene even if the dominant firm conduct will foreclose less efficient competitors, because less efficient competitors under certain circumstances might impose important constraints on the market power of the dominant firm. And I think this addresses one of the criticisms that also Kai-Uwe mentioned, that under certain circumstances, if you have an incumbent firm that is protected by high entry barriers, even the presence of a less efficient competitor might prevent the incumbent from abusing its market power. And it also might address the concern that the as efficient competitor test fails sometimes to protect not yet as efficient, but very dynamic competitors. Mm-hmm. And the last point really relates to this question about what is the evidentiary value of the as efficient competitor test in the narrow sense, so as a price cost test. And here I think what the Commission tries to do, and Anna and Kai-Uwe mentioned this, is to highlight that this is only one tool it will look at least in conditional rebates cases. And if it is carried out, it is only part of the entire parcel of relevant evidence. So it will also look at other types of quantitative and qualitative evidence to support the finding of foreclosure effects. And the real question that comes here is, so how strong must the other evidence be in order for the Commission to find an abuse, even if the as efficient competitor test is passed? So even if the as efficient competitor test doesn't indicate foreclosure effects. And I think that's something that will really also be perhaps at stake in future cases. And I really look forward to seeing what the courts are also deciding on this point, because I think in Intel Renvoi, for instance, the Commission also highlighted that there are other additional reinforcing factors that would suggest that there is foreclosure effects, even though the as efficient competitor test was quashed by the General Court. But the General Court highlighted that the Commission didn't carry out sufficient analysis with respect to these other factors. And I think this is something really interesting to see how much analysis there needs to be.
Because I think the Commission takes issues in general with all the analysis of the Renvoi case. So I think we will get some answers on that approach after we have the appeal.
But let me respond to some of those things, because I think that would be actually quite good, because it's a bit. So on the first part of intervening, even if it doesn't lead to full foreclosure, I think that there are 2 points to say. That's not new as such. You need to define what not full foreclosure is, and I'll come to that point. But it should not be something that would regularly be done, but require much more evidence, because typically the types of behaviors that lead to foreclosure. So if you look at conditional discounts or lots of discounting practices, are things that, if full foreclosure isn't achieved, generates more competition in the market. Okay, so a lot of the instruments that would lead to foreclosure, for example, bundling as well, if they don't lead to foreclosure, have pro-competitive effects. Okay, so kind of this continuity between kind of full foreclosure and a little bit or a lot of foreclosure doesn't necessarily exist in that way. Where it exists, really the question is, do you persistently increase the price in the market? And that is in principle also predictable with similar tools as we might be using in merger cases. So the question there to me is not, can you do it and can it be done? But the question is, what's the right evidence to use in order to show that there is anti-competitive partial foreclosure? And I think you don't get around an argument that actually credibly demonstrates that the price is going to go up, and that you are not going to get from some structural description of the market. I think that's the first point. I'm worried what this is signaling about the evidentiary standards that they're willing to apply. The second thing is this, even when they're less efficient, that is literally was also in the old guidelines, that could be the case.
Yep.
So the question again is, are we changing here? Is there an attempt to change what the evidentiary standard is or not? That would be my concern, that would be the case. What's important here is really the question, how difficult is it to enter in the market in general? And if we basically think we have 20 years of no one else entering, then it might be a good idea to help a slightly less efficient competitor who doesn't have the scale or something like that. That may be a reasonable argument, right? But it's really important to kind of gear the argument towards what you're trying to achieve in terms of competition in the long run. What was the third point? Oh, about the price cost test. As just simply one tool, I think.
Okay.
I think the issue is not so much if you have a price cost test, and it's appropriate to use a price cost test to see whether it's an as efficient competitor. Then that shouldn't be just one piece of evidence relative to other things that one says qualitatively. One would actually have to have some strong arguments that there is foreclosure for other foreclosure mechanisms beyond that, right? So again, I think it's a question where we need to be getting is to appreciate much more a tighter relationship between the type of evidence that we're using, the theory of harm, and what it can speak to in terms of the tests that we're applying. And I think we're groping towards that, but there are very powerful forces that are going against this, because and one just has to recognize this. And the Commission isn't, is I think much more on the effects-based side than some of the national authorities are, in basically saying, we know what is wrong, right? And now we shouldn't be prevented from intervening in those things where we know that's wrong. Or as the head of a competition authority a couple of weeks ago said in a speech to lots of economists, we've gone too far in using economic evidence, but we still need economists to give us theories to intervene in the cases where we want to intervene, right? So we need more theories of harm. We don't need the economists for evidence. And that's fundamental. And I think we just have to recognize that is a trend that is fundamentally opposed to what we've been seeing in the courts in the last couple of years.
Well, I think by the time these theories reach the court, it will be some time, because there is this lapses of time, no matter how much we try to advance things a bit faster, but the procedure is not always in the hands of the court. It's the arguments brought by the parties and the management or the way they present their arguments, and also external factors like confidentiality questions that keep the court from moving as fast as it would have wished to. Of course, we have here, I sensed a little bit the policy argument on the competition authority side on how to proceed in this case. Of course, this is something that a judge could see and feel, but then I would like to stress that it is for the applicants to make their case, and it is for the court to judge on the basis of the arguments brought forward to the before the court. Legal arguments that have to also take into account the economic aspects that the applicants or the defendants or the interveners in a case want to put forward. So the court considers that the legality of a decision will be judged on the facts and on law, and of course economics, which are the underlying principle of competition law, are a useful tool that will help us. And of course, it is important for the judges to understand the economic arguments. And there, I think, is a good chance not only for economists to be invited to provide theory of harm, but also help the court understand them within the context of legal proceedings. So with that, I would like to close our discussion, which has been very interesting and very challenging. And I would like to thank you for inviting me to join you for this, and looking forward to future possibilities to have these kind of exchanges. So I would like to thank you very, very much.
Well, and let me say, Anna, thank you very much for moderating this session, which is, and as we know, it's not always easy to talk between economists and lawyers, and even more difficult when it comes to practicing judges, because I think we all understand, but no, we all understand those difficulties and constraints as well that are there. The more important kind of these exchanges are, and so we're particularly happy that you could participate, and actually we're very active participant in the discussion as well. So I also thank the audience, where kind of lots of people have actually stayed till the very end, which I hope is a good sign that it was somewhat interesting. Let me mention that our discussions are available on the CCP YouTube library, where we have a page and one can at any time kind of look at this again. And so if you're interested or know people who are interested in this discussion, please let them know about this. And let me again tell you, there are these upcoming events, the CCP IO Summer School, which is has both the possibility of participating in person, but also online for someone who finds they have time and might still want to listen into that. And the annual conference, and do look out for that, because there are some really interesting panels as well on a lot of the issues that we're discussing at the moment. And I see Peter is posting all of that information, especially our YouTube playlist, on which you can find also other sessions that we've had in the CCP Conversation Series. Thanks again to everybody to listening in, to Anna for participating in this, and we hope to see you here again soon. Thanks very much.
Thank you.